Okay, so good afternoon, everyone, and welcome to the 2020 Friel Scanlan lecture. I'd like to extend a special welcome to the alumni and friends who've taken the time out of their busy days to join us. I'm also really delighted to welcome our colleagues and the students who are with us today. It's wonderful to have such a large group as part of the Temple Law community. And thank you in particular to our provost and former dean and colleague and friend, Joanne Epps, for making time to join us today. I'm sure it was the word bankruptcy in the title of the talk that drew everybody together. So the Friel Scanlan lecture is particularly meaningful because it gives us an opportunity to celebrate outstanding scholarship by a member of our own faculty. Legal scholarship is an essential component of our mission as a law school. Through our teaching, we help shape the legal profession. Through our scholarship, we help to shape law and society. This lectureship was established in 1989 by Francis A. Scanlan, a member of the class of 1950, in honor of the memory of his uncle and aunt, Francis S. Friel and Sarah G. Scanlan Friel. Mr. Scanlan was a successful maritime lawyer who, after earning a bachelor's degree and a law degree from Temple, was an adjunct professor at Temple Law School for more than 20 years and lectured in admiralty law in our programs in Athens and Rome as well. We are very grateful to Professor Scanlan and to his family for their generosity and for this opportunity to publicly recognize and honor excellence in what can often be somewhat of a solitary pursuit. The scholar we get to celebrate today is exemplary of our focus on innovative ways to use the law to increase social justice. Professor Jonathan Lipson has leveraged his very well-deserved reputation as a leading voice in business law, and in particular in bankruptcy law, to further our understanding of how corporations and other institutions can and should contribute to the social good, or should be held liable when they instead contribute to social harm. Today's remarks, I think quite wonderfully, are going to trace Jonathan's thinking in scholarship spread out over the last decade and a half about if, when, and how bankruptcy law should address egregious misconduct by large social or corporate entities, the Catholic Church, the Boy Scouts of America, large pharma, the Trump family, and more. So we have quite a range of topics to cover today. Jonathan's work is far from an academic exercise. Its intended impact is to tangibly increase justice for real people who have suffered harm at the hands of these Goliaths. That said, it's also an exemplary body of scholarly achievement filled with very precise thinking, impeccable analysis, and persuasive argument. It is also influential, accessible, and erudite. I know I always learn something when I read one of his works or discuss his work with him. I think it provides an example to all of us of how our expertise, insights, and scholarly contributions can make a real difference in the lives of people we may never meet. Jonathan has worked equally hard on behalf of people that he does have an opportunity to meet, the students and faculty here at Temple Law School. Jonathan cares deeply about our students and about our institution. He served for many years as chair of the Career Services Committee, and this year, as chair of the Colloquium Committee, he has put together a fabulous series with a focus on racial justice. He is the co-founder of the Temple 10Q, our business law newsletter, which he developed to support a community of business law-focused graduates and students through which the students can find mentors, gain experiential opportunities, and more. I am personally grateful for the many ways in which Jonathan has contributed to the strength, vibrance, and impact of our academic community. I know you will find what he has to say engaging and inspiring, and so I ask you now to please join me in welcoming my friend and colleague, Professor Jonathan Lipson.
Thank you, Dean Mandel. That was incredibly generous, and I'm grateful for the remarks. I am grateful for the opportunity to be here. In fact, I wanted to start with just a few words of thanks. In addition to my colleagues at the law school who have very generously honored me with the Friel Scanlan Prize, I specifically wanted to recognize a few of the folks who've really made all this work possible. And I promise it won't take a decade to get through all of it, a little less. My wife, I think first of all, Kathleen Noonan, has suffered through all of this work for several decades, and none of it would be possible without her. My kids also have been great support in all this, as well as the many students and colleagues around the nation who have provided incredible support to me in the form of their work, their collaboration, their analysis, their critiques, and so on. So thank you, thank you, thank you. I should start with confession, which will probably not be news to those of you who know me. I am not very good at following instructions. Strictly speaking, I received the Friel Scanlan Award for a paper called Bargaining Bankrupt, a Relational Theory of Contract and Bankruptcy. As the title suggests, that paper was about how the relationships of those who actually run the bankruptcy system affect its operation. And you might think, well, wait a minute. I thought the topic of this talk was sex, drugs, and bankruptcy. I didn't come here for Chapter 11, and I don't really know or care what relational means. I came for sex and drugs. We will ultimately get to that, I promise. But first, I need to explain a few things about how the bankruptcy organization system works and what it means to say that it is relational in order to understand how those characteristics affect problems of sexual misconduct, substance abuse, substance use disorder, and the social debts that those problems create. As many, but probably not all of you know, Chapter 11 is part of the United States Bankruptcy Code that businesses use to reorganize when they encounter serious financial distress. Reorganization can mean many different things, but it generally contemplates that a debtor will remain a going business with a reduced debt load, rather than liquidating its assets, which most of the time will produce deadweight losses. Many of the nation's more prominent companies, including 2 automakers and every legacy airline, have been through the process at least once. This glosses over a great deal of complexity, but Chapter 11 does this through a host of mechanisms designed to lead to something called a plan of reorganization. Plans are sort of a grand bargain between a debtor and its many stakeholders, a cross between a contract and a consent decree, this Fifth Circuit has said, and they can only be approved if they're supported by the vote of a supermajority of creditors. To say that the Chapter 11 system is relational is to mean that those who work in it at a high level of sophistication, the lawyers, the professionals, the bankers, the judges, and other functionaries, are in fact a fairly well-defined and discrete group with personal or institutional relationships. Their relational dynamics create expectations of repeat play and incentives to externalize losses to those not in the group, which can have both costs and benefits that I explored in the Bargaining Bankrupt paper. These costs and benefits have preoccupied legal academics for many years and typically focus on questions about returns to creditors and other stakeholders produced by the system. Which set of rules or system characteristics will produce the greatest economic outcome for the most people is the question usually asked, and it's an important question. At times, the debate about this question looks like it might map onto larger political constructs. So, for example, bankruptcy conservatives like Douglas Baird or Tom Jackson tend to embrace freedom of contract and private ordering as the best approach. Bankruptcy liberals, who include actual liberals like Elizabeth Warren, who used to have this line of work, tend to think that private order is a hopeless fiction and a system created by Congress and run by courts, which are obviously public institutions. But both sides of this debate would agree with Senator Warren's co-author, Jay Westbrook, that, in his words, wealth maximization is the consensus goal. That is to say, Chapter 11 should be concerned with economic welfare and not other normative or social concerns, such as the dignitary interests of creditors. as President Trump, whose casinos used Chapter 11 a record 4 times, famously said, Chapter 11 of the Bankruptcy Code is, quote, not personal, it's just business. Now, I think that's usually true, but I worry about a small but important and I think growing class of cases in which it would appear that the debtor's liability derives from misconduct that is so egregious that money alone may not be a sufficient remedy. These cases involve things like allegations of sexual abuse against organizations such as the 23 or so Catholic dioceses in Chapter 11, Boy Scouts of America in Chapter 11, USA Gymnastics in Chapter 11, as well as liability for the opioid crisis at companies like Purdue Pharma, Insys, and Mallinckrodt. I call these and similar cases moral bankruptcies because the underlying harm, for example, sexual assault or wrongful death, is under these circumstances morally indefensible. The organizations themselves may or may not have changed their ways, but the debt from this conduct, typically in the form of criminal or tort liability, has become an obligation of the organization and can become overwhelming. So these companies go into Chapter 11 with the goal of reorganizing in order to maximize recoveries for their creditors and remain going concerns. As a matter of basic bankruptcy law, the victims of this misconduct are simply creditors, no different legally than bondholders or trade creditors who've been stemmed. But of course, at a practical and human level, the victims here are not ordinary creditors at all. What distinguishes victims in these cases from ordinary creditors, of course, is the fact that they may want something more than and different from cash. They may characterize what they want as transparency or accountability or assurances that this sort of thing will never happen again. They may want truth and reconciliation or some other form of dignitary justice. But for these creditors, and unlike the president, is not business, it is personal. The questions thus framed are simple. Can the Chapter 11 reorganization system manage these cases? If so, how? And if not, what then? Ordinarily and historically, we might not have expected bankruptcy to attempt to do anything other than cash out these sorts of problems because that's what bankruptcy is about. At the same time, we might think that other systems, criminal justice, tort systems, for example, really are better suited at addressing the dignitary concerns of these creditors. Unfortunately, for reasons having nothing to do with bankruptcy, these other systems increasingly fail. In the early 2000s, the masterminds of Enron and WorldCom, 2 of the larger frauds that ended up in bankruptcy, were prosecuted criminally and served time. In the years since then, high-level white-collar prosecutions have all but vanished. While frontline wrongdoers in cases of moral bankruptcy, for example, predatory priests and Harvey Weinstein, may end up in jail, those who enable them and their misconduct may slip quietly under the radar of bankruptcy. Indeed, that's often the central legal and normative fight in these cases. To what extent can or should the bankruptcy system, which is designed to restructure corporate debtors, also be used to exonerate agents of those entities who may have caused or abetted the underlying harm? This is known as the problem of, quote, non-debtor releases. And it sounds dry and technical and pretty boring. But as I hope to show you, the conditions under which bankruptcy courts grant this form of exoneration, how they decide who will get released and who will not, present a core challenge to the role and rule of law. These releases are, for example, one of the central problems in the Purdue Pharma bankruptcy, where the wealthy Sackler family, which owns Purdue, seeks to use the system to, it appears, buy their way out of criminal liability, or even any meaningful investigation into and report about allegations of their wrongdoing. You might think, therefore, that I'll argue that Chapter 11 is not an appropriate venue for addressing cases of this sort at all. It should be wrong. As I'll explain, the bankruptcy system that Congress designed in 1978, when the Bankruptcy Code was enacted, has mechanisms that could accommodate some of the dignitary concerns of victims, in some cases more effectively than the ordinary civil or criminal justice systems that we have. But those who actually run the system, the lawyers, professionals, and judges who see the great majority of pattern-setting cases, seem to resist these mechanisms. Instead, their overarching goal in practice is to get a deal done at all costs. Now, in the great majority of cases, this imperative makes sense. But in moral bankruptcies, it cannot and it does not, because the problems are about more than just money. From a legal perspective, the issues, in particular the problem of non-debtor releases, boil down to questions of due process under the Fifth Amendment to the Constitution. You'll recall that provides that no person shall be deprived of life, liberty, or property without due process of law. In Mullane v. Hanover Trust, the Supreme Court said that an elementary and fundamental requirement of due process in any proceeding, which is to be accorded finality, is notice reasonably calculated under all the circumstances to apprise interested parties of the pendency of the action and to afford them an opportunity to present their objections. That is to say, bankruptcy courts, which are clearly government actors, cannot take away rights from claimants without some form of notice and an opportunity to be heard. The problem is that legal process, notice and hearing, can be expensive, and the whole point of Chapter 11 reorganization is to maximize economic outcomes, which often means minimizing legal interventions. So there's an obvious tension here in these cases between Chapter 11's efficiency goals on the one hand and the dignitary aspirations or requirements of due process on the other. My basic claim is that as it was designed by Congress, the Chapter 11 system had mechanisms sufficient to ensure minimal due process and thus to balance economic and dignitary concerns. But it is the relational nature of the reorganization system that has led to an environment in which getting a deal done, a financial deal done, is the highest priority and risks sacrificing the dignitary concerns and due process protections for victims of moral bankruptcies. This threatens to replace the rule of law with what I call the rule of the deal, which is obviously problematic in its own right. But it may also lead Congress to change the bankruptcy system. Because Congress has not always done a great job of revising the bankruptcy code, I worry that the reaction to problems of due process and social debt might lead to a political overreaction and undermine many important and valuable features of the system as it ordinarily operates. Needless to say, I have some concrete recommendations on this, really in two parts. So the rest of the talk, just two parts. In part one, I'll spend a few minutes unpacking the reorganization system and how and why its relational characteristics threaten dignitary justice in moral bankruptcies. And in part two, I'll talk about the procedural safeguards that I think the Supreme Court has recently articulated as being important in bankruptcy, and which the bankruptcy system can in fact use to better protect dignitary interests. To the extent we have any time, and I think we're supposed to end probably at 1, I'll take questions. Okay, part 1, Chapter 11 in 3 easy steps. Let me start by talking about the 3 steps in the reorganization process when the relational imperatives of system participants are in tension with the dignitary needs of victims in these types of cases. I'm going to use Purdue Pharma as the principal case study for this talk, not because it's typical, but because it's not. It is pushing the boundaries on a number of fronts, all driven by the tension between the relational and the dignitary. As I'm sure everybody knows, Purdue Pharma is the maker of OxyContin, which is the opioid generally considered to set off the opioid crisis in America. The drug was widely prescribed, allegedly based on misleading information about the drug's addicting qualities. This in turn led to the opioid crisis, which has taken about 500,000 lives, thus making it one of the nation's deadliest and greatest public health crises. Purdue is a closely held company owned and controlled by the Sackler family, alleged to be one of the wealthier families in the United States. There are credible allegations that certain members of that family were directly involved in critical decisions about the marketing, labeling, and sale of OxyContin that led to massive increases in opioid sales, thus enriching Sacklers, but also to massive increases in substance abuse disorder. Richard Sackler, who was the chair of the board of Purdue until 2018, apparently told Purdue Salesforce that the, quote, launch of OxyContin tablets will be followed by a blizzard of prescriptions that will bury the competition. The competition were not the only ones that were buried. This led to about 2,600 lawsuits against Purdue and, to a lesser extent, the Sacklers for wrongful death, personal injury, and so on. Before any court could rule on the merits, however, Purdue went into bankruptcy, September 15th of 2019. And this brings us to the first critical step in the reorganization process, which is commencing the case. We might intuitively think that bankruptcy is a bad thing that's done to a debtor by creditors, but actually it's a form of debtor relief. It's usually a voluntary decision that has many implications for the relational dynamic that matters here. Commencing a case automatically creates an estate comprised of all the debtor's property and imposes a stay of all civil litigation against that debtor. So for Purdue, this meant that as of September 15th of 2019, the 2,600 civil suits against it came to a halt. Criminal matters can continue, and as we'll see, Purdue and the DOJ recently announced a criminal plea agreement for the debtor, though not the Sackler family. The stay forces all creditors and other stakeholders of the debtor into a single court, the bankruptcy court. And this has obvious efficiency benefits and equally obvious relational implications. The disputes go from many different fora involving many different plaintiffs and defendants, lawyers, and many different judges to a single court involving a single federal judge and a much smaller number of lawyers and professionals. Because the venue rules are very lax, the rules about which bankruptcy court can hear a case, debtors can in many instances choose their bankruptcy court. In Purdue, for example, the debtors have only the slenderest connection to New York, which is where it filed its bankruptcy. But that slender connection was enough to enable it to choose the one judge in the Westchester division in New York that the debtors wanted, Robert Drain, who has presided over many large and important Chapter 11 cases. In the interest of full disclosure, I should note that I worked for Judge Drain when he was in practice and I was fresh out of law school many years ago. Halting litigation against a corporate debtor under Section 362 creates no dignitary or due process issues. But in Purdue, as in almost all moral bankruptcies, these cases also involved a special supplemental injunction under Section 105 of the Bankruptcy Code, which is really the first critical step taken towards gaining non-debtor releases that will really be the ultimate legal issue here. Section 105 of the Bankruptcy Code doesn't specifically give bankruptcy courts power to grant these supplemental injunctions. It's just an all writs statute. But bankruptcy courts have long used it to extend injunctive protection to employees of a corporate debtor because the corporate debtor itself is the only entity entitled to protection under the stay. Employees themselves are not debtors, officers, other agents are not debtors themselves, so without some special protection, they might be liable for suit. There's nothing inherently exciting about granting 105 injunctions, provided that they're granted for the right people and for the right reasons. In Purdue, the court granted a 105 injunction, not merely to protect Purdue's managers, who understandably need breathing space in order to focus on how to reorganize the debtors, but also to protect the Sackler family. This, in my view, was extraordinary. The Sacklers had already stepped away from active management of Purdue in 2018, before the bankruptcy. They were no longer on the board, had nothing directly to do with the company. Moreover, there are credible allegations that they took very large amounts of money and property out of the debtors in anticipation of bankruptcy, so that the company itself, now under new management, really may be adverse to the Sacklers. And to top it off, the Sacklers themselves were defendants in their own right in about 600 lawsuits, naming them personally for wrongful death and so on. Section 105 injunction stopped all of this. I'd say why? Well, because at the commencement of the case, the Sacklers and the debtors did something very unusual. They filed with the court an unexecuted term sheet laying out a proposed deal with 25 of the 50 state governments that had sued them. The deal was that the Sacklers would give up Purdue, put it into a public benefit trust for creditors, and add $3 billion, all in exchange for complete releases of liability, including, I think, ultimately criminal liability. This term sheet will in all likelihood form the basis for any plan of reorganization that Purdue proposes, and I suspect the exoneration of the Sacklers through the non-debtor releases that they want. In the meantime, at a very concrete level, this special supplemental injunction means that victims of Purdue, number one, cannot any longer litigate against the Sacklers in any other court. Number two, cannot conduct discovery of the Sacklers to determine whether the allegations against them are true. And number three, cannot recover from them personally, except to the extent the Sacklers so agree to a plan for the debtor. One does not have to be a constitutional law scholar to see the problem here. The stay at the beginning of the case would prevent any meaningful opportunity to learn about the Sacklers' culpability or any way to assert claims against them if they were liable. Now, the Section 105 injunction in Purdue was appealed, but the appellate court sustained it, in essence, saying that it was temporary and the real action is going to come in the plan of reorganization, which takes us to step 2 in the process, restructuring. Restructuring can mean many different things, but it almost always depends on negotiations among key participants in the Chapter 11 process. In particular, counsel to the corporate debtor and counsel to any official committee of creditors that may be formed to represent groups of creditors. This is where we really start to see relationalism in action. When Congress created Chapter 11 in 1978, it did something extraordinary. It said that managers of the corporate debtor could remain in possession and control of the debtor while it was in bankruptcy, even though those same managers may have played a role in the conditions that led to bankruptcy in the first place. Under prior law, management was typically tossed out and replaced with a trustee. But by the 1970s, everyone recognized that this probably meant that businesses would just liquidate if they went into bankruptcy, and that would produce greater losses in most cases than would reorganization and survival. But this also meant that we were leaving the foxes to guard the henhouse, a classic agency problem. So Congress created a number of checks and balances in the system. The most important would be an official committee of creditors or other stakeholders appointed under Section 1102. Although individual debtors, organization debtors, and individual creditors themselves are not usually repeat players in the Chapter 11 system, possible exception being Donald Trump, the lawyers and other professionals who represent and advise them are. Thus, if we look at a sample of 1,200 very large Chapter 11 cases from the past 20 years, we find that really only 3 firms, Kirkland & Ellis, where I used to work, while Gottschall and Skadden, totally dominated, representing about a quarter of all corporate debtors. And most of this happens in only 1 or 2 courts, New York or Delaware. On the creditor side, one firm, Aiken Gump, happens to dominate in the large company context as well. They lead the list of firms that repeatedly represent creditors' committees in large cases, accounting for about 10% of all committee representations in the 1,200 large cases in the sample we're discussing. These top firms in Chapter 11 often end up together in the same cases. That is to say, they're paired representing the debtor or the creditors committee in about 9% of cases in the sample. More important, they often appear in front of the same judges over and over. 2 firms, Aiken Gump and Milbank Tweed, have had lead roles in nearly 1/3 of Judge Drain's cases, large cases. Aiken Gump is important because, as noted, they are among the most common firms likely to represent creditors' committees, and also because they are counsel to the creditors' committee in Purdue. Milbank is important not only because they represent many members of the Sackler family in the Purdue bankruptcy, but because, as mentioned, that's one of the law firms where Judge Drain worked before he became a judge. Now, this is not considered a conflict in a technical sense, but of course it might tell us something important about the relational expectations that the judge and counsel have if they frequently appear in front of one another. Repeat play has obvious efficiency benefits. These firms have great expertise and in all likelihood, very functional working relationships with one another and with Judge Drain. The problem is that the relational dynamics of these cases also tend to lead those inside the group to make compromises that may push losses to those outside the group. Here, those outside the group are the victims of the opioid crisis, especially those whose concern is dignitary justice. So it's not surprising to find in Purdue that counsel to the creditors committee entered into a set of stipulations, mini deals, with the debtors and in some cases the Sacklers, in which they ceded important rights and powers in the bankruptcy code intended to protect creditors. These include the power to seek the appointment of an examiner or a trustee, and these powers are important because they are a source of leverage over management if management is not being responsive. Regardless of the parties' relationships, restructuring typically involves 2 subsidiary tasks. Number 1, investigation. Number 2, negotiation. The creditors committee in Purdue appears to have been working hard to investigate the debtors and the Sacklers. While it appears that the debtors have produced some information about themselves, significant amount of information about themselves, the Sacklers have been less forthcoming. Unfortunately, because the Sacklers themselves are not debtors, their obligations to produce information are just not well defined. Although the creditors committee has the power to subpoena the Sacklers, the same stipulations I mentioned a moment ago tie their hands in certain ways. In any case, the debtors have promised that important information about Purdue will come out, they say, but only after a plan of reorganization is confirmed and the deal is done. This is a little like when my kids come to me and say, "Dad, I did something wrong. If you promise not to get mad at me, I'll tell you what it was." The timing doesn't work there. And as for the Sacklers, right, we have no idea whether any information about them or the entities through which they control the debtors will be released. Investigation is important, negotiation is as well, critical part of restructuring. So while an official committee is investigating a debtor, it's also trying to negotiate a plan to reorganize the debtors. Although negotiations are and obviously should be confidential, it appears that the parties in Purdue have made progress towards a plan that would implement the term sheet mentioned earlier. The key, of course, is that the Sacklers would release the company, put in $3 billion, and in exchange get a complete release from civil liability and, realistically, criminal liability. You may wonder, how can a bankruptcy court, which is an Article 1, that is to say inferior federal court, release criminal charges? The answer is that it can if the charging authorities agree to give up their criminal claims. And here, that is what the Sacklers have effectively required in their term sheet, and is what the Department of Justice, which is really the lead prosecutor in these cases, in this case, seems headed to give them. On October 21st, 3 weeks ago, the Department of Justice announced that it had entered into an agreement with Purdue, under which the company, but not any individuals, would plead guilty to conspiracy to defraud the federal government and for making kickbacks to healthcare providers and others. The company will be released from liability in exchange for a recognition that the U.S. has about $8 billion in claims against the company. This is obviously an enormous amount of money and will substantially dilute recoveries by all of the debtors' many other creditors. This is obviously problematic, but what's truly extraordinary about this is that the DOJ also entered into a separate settlement with the Sacklers, under which the Sacklers will pay only $225 million in exchange for the DOJ's release of all of their civil liability. It's extraordinary because it's about 2% of what the company itself will pay. Yet the DOJ's own plea memoranda says that the Sacklers themselves exercise substantial oversight over management's operations of Purdue, and in the DOJ's terms, were the debtor's de facto CEO. The court is scheduled to consider both the company settlement and the Sackler settlement next week, 17th of November. These proposed settlements have received an extraordinary amount of attention. Just today, a group of 15 U.S. senators, led by Tammy Baldwin and Sheldon Whitehouse, but including Senator Warren, sent a strong letter to Attorney General Barr questioning the propriety of the Purdue settlement and asking him to delay presentation to the court for approval. Regrettably, the senators wrote, DOJ's position appears consistent with the historical leniency it has shown to Purdue and members of the Sackler family. These senators worry that these settlements and the deal embodied in the term sheet will, quote, function as a rebranding opportunity for the company and the family's public image. This, the senators say, is not justice for the families that have lost loved ones. In other words, these senators worry, as I think do many of us, that the rule of the deal will displace the dignitary concerns of the victims. Okay, step 3, the plan and non-debtor releases. From a dignitary and due process standpoint, the DOJ settlements are problematic because they will likely force a resolution of all issues in the case in a plan that implements the term sheet. You may recall from the introduction that plans can only be approved with a supermajority vote of creditors. Moreover, creditors cannot be asked to vote on a plan without also receiving a court-approved disclosure statement, a document that should provide a great deal of information about the debtor and its plan. So you might say, well, won't creditors who care about dignitary justice simply vote no? Maybe, but it probably won't matter either, for reasons captured by 2 colorful bits of bankruptcy jargon: death trap and cram down. A death trap is a provision not normally found in a plan, which essentially says that if creditors vote for the plan, they get one probably good thing, and if they don't, they get something worse, or maybe nothing at all. In other words, if they vote no, they fall for the trap. It's not quite duress, but it can come close. Here, the death trap is that if a plan is not confirmed to DOJ's liking, they can exercise their civil forfeiture rights and take all or almost all of the debtor's assets, leaving creditors with nothing, or at best, a costly and protracted litigation over whether DOJ could actually do that. Even a plan that pays creditors 10 cents on the dollar is better than DOJ taking everything. So creditors will have, I think, no choice but to go along with whatever plan the DOJ and the debtors come up with. It's useful to contrast Purdue and the Sacklers with the only other opioid maker that went through Chapter 11 so far, Insys. Unlike the Sacklers, DOJ prosecuted Insys CEO and founder John Kapoor, who was convicted by a federal jury for paying kickbacks to drive sales of opioids, one of the crimes that Purdue is pleading guilty to. Unlike the Sacklers, the de facto CEO of Purdue, who will pay only $225 million, Insys CEO Kapoor was sentenced to 66 months in prison. Now, we don't know whether DOJ will charge the Sacklers criminally because as a formal matter, they have still reserved the right to do so. But there is no indication that they will, and there's good reason to think that they won't. This is because if the DOJ does prosecute the Sacklers criminally, it seems virtually certain they will withdraw the term sheet and the deal that they have proposed. So unless DOJ wants to blow the whole thing up, which perhaps a Biden DOJ would want to do, the deal will be sealed if the court approves these settlements. Of course, some creditors still might reject the plan that seeks to implement this deal, and this is where cram down comes in. Although we say that Chapter 11 plans require a supermajority of creditors, in operation, the system is really more like our friend the Electoral College. It's not a supermajority vote of all creditors that counts. It's not a popular vote, but it requires only a supermajority within at least one class of creditors to get a plan approved. Here, it turns out that the DOJ settlement requires that the DOJ gets to be in a class all by itself. So since this means that they're likely to support the deal and the plan, they are a supermajority of their own class. This means, as a practical matter, that the plan can be crammed down against all other creditors, whether they vote for it or against it. All the other creditors will be in other classes, and so in effect, their votes may not count so much. Now, this is controversial, and I'm sure that the debtors will propose a plan that many creditors support. But a plan that follows this path will make creditor protections in the bankruptcy code illusory. There will be little transparency about the Sacklers. Judge Drain could require them to produce information in the disclosure statement, but I suspect he worries about scaring them away from the negotiating table, as I suspect DOJ is worried. He likely views the deal in the term sheet as the best deal that creditors are likely to get. So even though a plan will probably eliminate any right to sue the Sacklers personally, and we probably won't know the truth about the allegations against them, Judge Drain is unlikely to stop that. In that event, Purdue would be a triumph of the rule of the deal over the rule of law, a triumph made possible in part by the relational dynamics of sophisticated Chapter 11 practice. Last summer, law professor Ralph Brubaker and investigative reporter Gerald Posner published a controversial op-ed in the New York Times, worrying that the bankruptcy process would enable the Sacklers to, quote, get away with it. Unless the senators I mentioned recently, a moment ago, are able to persuade Attorney General Barr to slow things down, it seems likely that the deals embodied in the term sheet, the DOJ settlements, and in all likelihood a plan that implements them will make that so. Okay, that's the process, its relational dynamics, how it affects dignitary justice. Number two, what to do about it. I spent a significant portion of 2017 and 2018 working on a case that ultimately went to the Supreme Court called Jevick. That case involves something called a structured dismissal, which is essentially a bankruptcy deal in which insiders can get many benefits of the plan, in particular these non-debtor releases, without having to worry about even the meager procedural protections we've been talking about so far. In this sense, the structured dismissal is the apogee of the rule of the deal over the rule of law. I worked with a group of academics to help the Supreme Court understand what was at stake, and they did. Although they did not totally prohibit structured dismissals per se, they said that deals cannot, in their words, circumvent the bankruptcy code's procedural safeguards unless they are supported by strong bankruptcy-specific benefits. In writing about Jevick after we won at the Supreme Court, I suggested that the case appears to specify three types of procedural safeguards. Number one, participation. Number two, predictability. Number three, procedural integrity. These, I think, provide a helpful checklist of the sorts of things we can do to address the relational excesses in moral bankruptcies. Okay, start with participation. Applied here, it seems to me that participation comes chiefly from making the plan, process, and vote meaningful. We should watch those death traps and cram-downs. One can imagine going even further. In 2006, I published one of the first studies of the church bankruptcy cases, an early form of what I now call moral bankruptcy. I argued then that what those cases really needed was a kind of truth and reconciliation process, a process where victims and those in the church who made problematic decisions about the placement of priests could meet, could tell their stories, and could try to gain some closure and help. The churches, of course, would still have to pay money, but the process would also protect the dignitary interests of victims. Although a couple of dioceses experimented with something like this, most have just tried to cash victims out. I suspect that's often because it turns out that that's what the personal injury lawyers who represent victims in fact want. Truth and reconciliation would be costly, and we always need to be sensitive to that when we're in Chapter 11. But I think taking the victim's experience seriously in cases of moral bankruptcy is a critical form of participation that these cases seem to lack because their relational characteristics are driven by the deal imperative. Number two, predictability. To an important extent, the rule of the deal introduces a kind of unpredictability that threatens the integrity of reorganization and thus its capacity to provide due process to victims of the kinds of harms we're talking about. Bankruptcy is organized around settlement, and settlements are clearly a good thing. They reduce costs, they reduce burdens on courts and litigants, and so on. But they can also render outcomes less predictable. Debtors like Purdue or many of the church bankruptcies often go into bankruptcy before there's been any adjudication of the underlying harm on the merits. Recall, for example, that due to the stay and injunction at the outset of Purdue, there's been no trial or summary judgment as to Purdue or the Sacklers, no discovery that would have been revealed in that process. And so, as a practical matter, it is very difficult to know whether or to what extent Purdue or the Sacklers should be liable at all. Robert Mnookin, who's a famous law professor at Harvard, has taught us all that settlements usually occur in what he calls the shadow of the law, which is, of course, true. But for that to happen, you still have to have some fixed object, some definition, before you can see the outline of the shadow. My concern is that without some way of independently and credibly determining liability in these kinds of cases, we won't be able to know where the shadow really is. There are, however, two mechanisms that bankruptcy courts could use to, I think, help here. One would be test trials. Rather than halting all litigations at the outset of bankruptcy, as happened in Purdue, bankruptcy courts, could permit one or a handful of representative lawsuits to go to summary judgment, or perhaps to trial if that could happen on an expedited basis. This would have the benefits of forcing information into public, right, because summary judgment and trials are usually public, and a neutral adjudication of the merits according to the rule of law. Now, I'm not making this stuff up. There's precedent for this. It happened in earlier cases like H. Robbins, Drexel Burnham, and so on. But the modern moral bankruptcies today seem to have very little patience for processes of this sort. A second would be to use bankruptcy examiners to investigate and report on the debtor's collapse. Chapter 11 says that bankruptcy examiners are supposed to be mandatory in any large case, large being defined as a company with more than $5 million in unsecured debt, and should be appointed in any case where it's in the interest of creditors to do so. When Congress created the role of the examiner, they seemed to think that examiners would be a routine form of check on management in Chapter 11 cases, in effect supplemental to creditors' committees. Now, I spent some time studying bankruptcy examiners because I wanted to know whether they were being used as Congress had intended. In fact, I found that they're vanishingly rare. They are sought in fewer than 10% of cases where they should otherwise be mandatory, that is to say, big cases. And even if somebody asks for one in a big case, a court is not so likely, only half the time, willing to grant the request, even in cases where they're mandatory. While examiners have played important and sometimes controversial roles in big reorganizations of the past, Enron, WorldCom, and Lehman Brothers, for example, really nobody wants them. Nobody likes them. And the basic problem with examiners, I think, ends up being relational. The examiner is likely to be an outsider, as, for example, was former prosecutor Anton Balukas, who was the examiner in Lehman Brothers. As an outsider, an examiner may impede the deal. But examiners could play a valuable role in cases involving the sort of misconduct that we see at issue in cases like Purdue, Boy Scouts, and so on. In these cases, we don't know who is or should be held liable, and so an examiner with subpoena powers could conduct an independent investigation, write a report that assesses allegations against whoever is accused of wrongdoing in connection with the debtor, in order to determine whether the bankruptcy process is being used properly, whether, for example, individuals like the Sacklers are deserving of a release or not. There were calls for an examiner in Purdue. I know because I made them. I wrote a letter last year, joined by about 20 law professors, formally asking the United States trustee to ask the court rather to appoint an examiner. But the US trustee and all other creditors have declined that invitation. I think this is in part because Judge Drain himself has made quite clear that he has no interest in seeing an examiner mucking about in his case. Now, like truth and reconciliation, examiners are not cheap. They will add cost to the reorganization process, but they can be an effective alternative to a test trial in order to get an independent assessment of facts and law critical to claims about liability. They can provide transparency and predictability in a process that is otherwise drawn to confidential deal making. All right, item 3, procedural integrity. The court's ultimate goal in Jevic ultimate concern rather in Jevic was about procedural integrity. The Supreme Court worried in that case that, quote, changes in the bargaining power of different classes of creditors could create risks of collusion. The example they gave there was two groups of powerful creditors squeezing out a group of weaker creditors. In cases of moral bankruptcy, the relational dynamics of repeat players will drive them to come to some kind of deal, as we are witnessing in Purdue. Because that deal cannot slow down to accommodate the dignitary concerns of creditors, there will be great pressure to squeeze them out, to cash out their concerns about transparency and accountability. The problem, therefore, in my view, is not collusion in any ordinary sense, but perspective. I know some of the participants in these cases, and my sense is that they truly believe that they are doing the best they can for the victims of the harm in question. And they might be right if your only metric is money. They may well maximize recoveries for creditors, and that can certainly be an important and positive contribution. But cash may not be all or even any what victims of moral bankruptcies want. Conclusion. I have a colleague at another law school, a man who I have admired and respected for many years, who studied the Chapter 11 system closely and declared it corrupt. Now, although I have great respect for this professor's work, I don't actually concur. I do not think the Chapter 11 system is corrupt. Instead, I think it is highly relational in ways that may be functional in ordinary cases, but potentially dysfunctional in moral bankruptcies. If I'm right about repeat play among distressed professionals, then they literally cannot see how bad cases like Purdue and Boy Scouts of America look to the outside world, much less to the victims. They see a world of deals in which problems can always and only be cashed out because that's what they do. My ultimate claim, therefore, is that on its present course, the Chapter 11 system is not both sustainable and legitimate. If companies like Purdue and insiders like the Sacklers use the Chapter 11 system to conceal wrongdoing, to get away with it, as Posner and Brubaker might have it, Congress will inevitably step in, as it has in the past, and make potentially massive changes to the system. That would be unfortunate. With all due respect, and the important exception of the expertise of Senator Warren, I would tend to prefer to see that the professionals who run the system, the judges, the lawyers, the advisors, do a better job of policing themselves. And they can do this if they want to. They have the tools in the bankruptcy code that Congress actually enacted. The important question for them is whether they have the vision and the courage to use those tools. Thank you for your time and attention. Thank you, faculty and Dean Mandel, for the Friel Scanlan Prize. If folks have questions, I think we have a couple minutes, 6 minutes. I believe if you'd like to ask questions, you can either raise a hand or perhaps just write in chat. This is Zoom. It's our first Friel Scanlan by Zoom, so we're figuring it out as we go.
John, I think Edward DeLuca has a question.
Okay.
Hi, how you doing? Thank you so much for the presentation. I don't want to give away my bias, so I don't know if you can see my picture with Elizabeth Warren. I guess my question is, what is the difference in your opinion between functional relational operations and corruption, right? Because corruption is very functional for those that are inside the system that is going on. It's the effects that it has on external parties, like the creditors that you talked about today, that makes it corruption. So what is the substantive difference between those two for you?
That's a good question. I think of corruption as just being a much more serious form of misconduct. I think it requires the sorts of elements that might constitute conspiracy, or really conspiracy, I guess, bribery, what have you, which I just don't think you see in any way in Chapter 11. Now, there's a continuum, right? Obviously, we all know that there are many contexts in which we have great concerns about self-dealing that is abetted by relational context. The revolving door in administrative and regulatory settings, I think, is probably a pretty good example. I don't think a place or a thing over which you can make a clear, hard and fast distinction. I've seen no evidence of corruption, because although I think that participants in these cases do have expectations of repeat play, I think their intentions are probably pretty good. I think they probably think that they're doing the right thing. I don't think that they're intending to harm others. I think they think that money is the best they can do in these cases. And so that's the thing. That is the thing that they're going to do. Intent, I think, is a critical element of any serious claim of corruption. And I just don't see it here. But, obviously many things could come out that might change that in the future. So I guess relational means, you have folks who expect to be working together in the future. Things like reputation matter, things like the threat of future favors, future sanctions, all those things will drive, conduct that we worry about. But I don't think it necessarily rises to the level of corruption.
Professor Lipson?
Yes.
This is Bill Rochelle. I wonder if you were to remedy the problems you identified through amendments to the Bankruptcy Code, what would you do?
That's a great question, Bill. It's good to hear your voice. So as Bill knows, but maybe those who are not bankruptcy nerds, aficionados may not know, for many years there's been a move to amend the Bankruptcy Code to change those venue rules that I mentioned earlier. And I've basically sort of sat that debate out. So if you're looking for sort of a position on venue, I'm not actually going to offer it, because I basically think the most important thing is for people to do the right thing wherever they are. As I said, I think most of the important tools that we need to balance the dignitary and the relational, the financial and the truth, we have those tools. We just don't use them, and that's the problem. Having said that, I think one tweak that might be useful, and this is an idea from Adam Levitin, I can't claim it myself, is that we amend the Bankruptcy Code in some way to make it more difficult to grant third-party non-debtor releases. And so, for example, you might say that in order to grant a non-debtor release, there has to be some independent determination that the recipients of the release, are entitled to the release under whatever generally applicable standards we say count, and that there's some reasonably transparent process for reporting on that. There are a number of ways that you could tweak the bankruptcy code to address the, I think, specific problem of non-debtor releases. But I suspect that that's not all we get. I suspect we get lots and lots of other changes to the bankruptcy code. The most recent set, the 2020 revisions, I think the jury's out on those, but we know that the 2005 amendments to the bankruptcy code, they didn't go so well. So I am always very nervous when Congress gets the itch to amend the bankruptcy code. I think they did a great job in 1978. I think with the expertise of people like Senator Warren and Representative Porter, they might well be able to do a much better job, but I worry that outside lobbyists and folks like that can kind of get control of the process and worry about the outcome there. So except for a modest tweak like that, Bill, I'm not sure that there's much that I would want to do. I think we have time for one more question.
I'm not seeing anything on Zoom, and so at the time at 1 o'clock, I hope everyone will join me in thanking you, Jonathan, for what was really a wonderful and very broad talk. I appreciated it very much. I know we all did. Thank you.
Thank you, Rick. Thank you all for joining. Take care.